him on Monday, what we do.
Right?
See him on Monday.
I didn't know if it was somebody that we could just.
Oh, who is it?
Percy Avery. Well, I was gonna ask, and it's somebody that hasn't been here in time. We could get from.
And he has it. It's a 2020 case. It's the only case we have.
All right, just give a new date.
Okay. Thanks, Judge.
Thank Kathy. She's the nice one today.
Sit. None.
You know I'm on.
No record.
I'm on Zoom. People of the State of Michigan versus Flynn Thompson, 1822063. Mr. Thompson's here with his attorney, Mr. Knopfinger. Mr. Gabriel is the prosecutor, and Ms. Bordeaux is representing the victim in the case. Mr. Thompson pled to a charge of criminal sexual conduct in the second degree, a felony, punishable by up to 15 years. Plea agreement involved pleading no contest to this charge. Counts 1 through 9 would be dismissed. Further, the prosecution recommends the minimum sentence not exceed 1 year. And Mr. Knopfinger, does Mr. Thompson have any objection to continuing on video today?
No, Your Honor.
All right. Now, in the body of the pre-sentence report, Mr. Thompson indicates that he is going to seek to withdraw his plea, that he is not guilty of this, and therefore I sent an email around saying, please let me know what he wishes to do and talk to Mr. Thompson. You know my policy on CSC cases that are, first of all, I really don't like doing CSC cases with a no contest for this very reason. But I don't take guilty pleas or no contest pleas from people that aren't guilty. And if he wants to assert his innocence, his answer is to go to trial, not to take a plea and then say, I didn't do it. So if he wants to, I'd be more than happy to allow him to withdraw his plea and to go to trial on all the original charges without the plea agreement. Did you talk to him about his options and what does he wish to do?
Yes, Your Honor. And we did have a chance to review the PSI and talk about that very issue. We do intend to proceed today. I think that there was some alarm when we saw a recommendation from the department and then also our plea agreement diverged somewhat. So now that we understand that we are prepared to move forward today, there's not an intention to withdraw the plea.
All right, thank you. All right, so with that, do you have any additions, corrections, or deletions?
No, Your Honor.
All right, Mr. Gabriel, do you?
I would just query whether or not Mr. Knopfinger would prefer to have that language stricken from the PSI. I don't know how this is all going to go, but if it ultimately goes wrong down the road, is he going to want that language in the PSI? It's okay with me if he wants it in there.
I wouldn't object to it being stricken, Your Honor.
All right, I will strike under defendant's description of the offense. And I'll leave in just entered a no contest plea and I'll strike the rest. All right, with that, let's go to scoring. Prior record variable 7 points, level B, offense variable 55, level 5.
Concur with scoring.
No objection.
The advisory guideline range would call for a sentence of 29 to 57 months on the minimum. The plea agreement does involve a recommendation from the prosecutor that the minimum sentence not exceed 1 year. Therefore, I will comply with that agreement, not interfere with it, and we can proceed with sentencing. Mr. Knopfinger?
And I just want to note a couple things beyond the report. And having sat down and discussed with Mr. Thompson, he doesn't object to being placed on probation. I think there was some issue about he doesn't agree that he has a substance abuse issue. So he's agreeable to probation. But with that being said, there's some worry, and I think it's indicated in the report that if he doesn't have a place to stay and if he doesn't have a car and he doesn't have a job, then there's going to be some difficulty here in compliance on probation. And so I think that's where he comes from when he says, look, if you're going to put me on probation, given my circumstances, I worry that I'm just going to fail. So I can't do that, right? We talked about if he is homeless, one option would be for the court to consider placement in the Twin County Probation Center, just for the reasons that if he's homeless, he would have a jumping off point for him to get a job and do those things. So I'd ask the court to consider that, and as it's already indicated, respect the plea agreement.
I do consider that. That's what I need to know. Under the new rules, the defendant has the right to say, I don't want to do probation, which is what I took him to be saying. He doesn't have to have good reasons or bad reasons. I don't have to agree to him. I can't force him into probation if he doesn't want to do probation. So, which is it? Does he not want to do probation, or does he want to do probation? I'll tell you right now, it's not going to get him a lesser jail sentence than if he did it the other way. So he's right. It only carries danger for him if he's not able to follow through on it, and the rest. But, I'm not going to reward somebody to go into a program they don't want to do, because I respect people that say, hey, look, my life, what's going on, probation would not be easy for me and I cannot do it. I'm not inclined to do it, or I cannot do it. I respect that. I understand that. But, so that's where we're at. So does he want to do it, or does he not want to do it?
From my discussions with him, he's not opposed to it. I guess I would defer to him.
Okay, let's hear from Mr. Thompson. Now, Mr. Thompson, you pled no contest.
Yes.
And in your pre-sentence report, you indicate that you believe that, probation would be difficult for you, but if placed on probation, you have this belief you're going to get less jail time. Well, let's take that out of the system. Let's assume I'm going to give you the year jail no matter what, and then put you on probation, or not. You don't do probation because you just want to get out of jail early, is what I'm trying to tell you, because it can lead to problems, especially with your guidelines as they are. So with that, what would you like to tell me? Now, you pled no contest. You don't have to tell me anything, but this is your opportunity.
I'm not trying to get out of jail early. I'm not opposed to probation at all. I would rather have probation and be able to go to the probation center so that I don't fail.
Okay,
So
good. All right. Mr. Gabriel?
Thank you, Your Honor. Your Honor, it's my understanding that, and I believe that this would be the maternal the paternal grandmother. My victim's grandmother is present in the court and would like to address the court on behalf of the victim.
All right, thank you. What is it, ma'am, that you would like to tell me on behalf of the victim in this case?
Well, Your Honor, I just have a few things that I want to say. I believe that Mr. Thompson targeted this family, knowing that Olivia's mother was vulnerable from a recent death of her father and marital problems. He chose this family because he knew there were 3 girls and that was the prey he was looking for. And Olivia's mother knew bringing Mr. Thompson into the home and exposing her children to him was wrong, because she asked the girls to keep him a secret. Mr. Thompson's actions have forced Olivia to grow up too soon. At 13 years old, she should never have been put in this adult situation. He's damaged her ability to trust people. The court system has damaged her ability to trust as well. This has drug on for over 3 years. Why, when we tell our children to tell someone if someone is being inappropriate with them, does it take so long to work it through the justice system? It's like we put very little value on our children and more value on the perpetrator. We also teach our children to be honest and admit when they have done something wrong. Olivia wants to know if Mr. Thompson didn't just admit to his guilt. What happened to Olivia has caused her problems. She suffers from anxiety and depression. She struggles in school. She has lost so much, and all from Mr. Thompson's actions. Olivia questions if she is to, especially if telling her mom is the reason her mom no longer loves her. I will never forget Olivia talking to me and her dad and asking, "Do you know why my mom doesn't love me anymore? I remember when she used to love me." The damage done by Mr. Thompson doesn't end with Olivia. He has damaged an entire family. All these beautiful girls have been hurt by this man's selfish actions. 3 girls who no longer have the family they knew, and 3 girls without their mother. But maybe that's for the best, because a mother should never choose a man, especially a predator, over her children. In closing, Your Honor, I would like to ask that Mr. Thompson be responsible for paying for Olivia and her sister's counseling. Thank you for allowing me to speak.
Did you submit anything to the victim witness unit about the counseling, the cost of that? Did anybody?
No, I have not. I didn't know I could do that.
Did you fill out crime victim? They should have received a packet from the Crime Victims' Rights Act at the beginning of the case.
Nope.
That would have told you that you can get reimbursement from the state and also from the defendant. Mr. Gabriel, what do you want to do on that?
Well, yeah, and what I can indicate is that this is the first time I've met or heard from Ms. Bordeaux. I have dealt with Olivia. I've called and we've set up Zoom meetings with Olivia. Last name won't be mentioned. I've also talked with her father, and I talked with him, who is the guardian, at the evening. I believe, I even remember being at my desk at home calling him and talking to him about this proposed resolution. He was fine, absolutely fine with it, indicating that he did not want to have his daughter testify. That's why the agreement was the year in jail. I, and the court might remember at the time of the plea, having a concern about, well, am I just setting him up for failure after he does a year in the county jail and then he's on probation? In deference to the Department of Corrections, my thought process here was that he deserves the year timeout, sitting in jail, thinking about what he's done, considering what he can do when he gets out, given whatever cards life has dealt him. So nobody's just, it's not like he doesn't have an opportunity to have contact with people, set up things. But I believe, and I was involved in the creation of a program for sex offenders to be put on probation, to be monitored, and to make sure that they get the resources to try to address their predatory behavior. I don't deny for a moment that there's a predatory aspect to this. I also am fully aware of the fact of what it would take to put this young lady through a trial. And as the court has had an opportunity to review the pre-sentence investigation, it sees that this case was not without some problems. So I do believe that my sentence agreement, that he get locked up, that he is going to be on the sex offender registration list, but that he be supervised upon release and given the opportunity to get some resources, to have some guidance, but also to know that we're watching, because that's the best we can do right now. And under the circumstances, that's what I'd ask the court to consider imposing. I'm not defending Mr. Thompson's behavior. I acknowledge, and like I say, I spoke with this young lady. I have the same feelings about how their life has been turned upside down. But I also recognize what a trial would put her through. So that's why we're where we are.
All right. So in terms of the counseling costs, I would ask you to see, I don't know, whoever is the guardian or responsible person for those bills needs to submit them to the state Crime Victims' Rights Unit or to the victim unit here. So I'll leave restitution open because that can be part of a sentence. If verifications provided to the victim witness unit or to the Crime Victims' Rights in the state, that can be considered. And clearly the cost of counseling would be such a thing that would be covered. placed on probation for a period of 5 years, subject to the terms of probation that are listed. I'm allowed in a CSE case to order up to 5 years, so I'll order 5 years. I'm ordering 1 year jail, credit for 85 days served, and there is a probation order will be prepared. There's a $68 state cost, $130 crime victims assessment, and there should be, no, he has a previous felony. Okay, and then probation oversight fee is $30 a month unless placed on tether, at which point, or electronic monitoring, it'll become $60 a month. As far as the center goes, I'm not ordering the center. It's strictly jail, and then we'll look at the center at the end as a term of probation if needed, but not as a term for the initial jail sentence. Ms. Bordeaux, if I'm mispronouncing your name, I'm sorry, but if you could have whoever's responsible for those bills to be submitted or reviewed and sent in, that would be helpful. There's been no request through the victim unit here.
Okay.
All right. So yes, I agree with your position also. And so I'll do that. Mr. Thompson, your sentence is pursuant to your plea. It's within your guide. It's not within the guidelines, it's below the guidelines, but it's pursuant to your plea agreement. Therefore, you're being provided 3 forms advising of what your rights on appeal are. I'd ask you to sign one copy acknowledging that you received them